Well, the Supreme Court is entering the clash over transgender athletes. This term, justices will hear two cases challenging state bans on biological males competing in women's sports. The rulings could redefine school policies on fairness and inclusion. Tara Mergener explains.
The cases focus on whether these laws in Idaho and West Virginia violate federal protections. Supporters say the measures preserve fairness and competition, while opponents argue they discriminate and violate the Equal Protection Clause of the 14th Amendment and Title IX. Idaho's legal fight began with one runner.
I was just feeling overwhelmed at the amount of anti-LGBT discrimination.
In 2020, the state passed the nation's first law requiring athletes to compete by biological sex.
To provide those opportunities that we have had for almost the last 50 years.
Transgender runner Lindsay Hecox sued after being barred from trying out for the women's cross-country team at Boise State.
It was just preposterous and unfair for us to allow boys to be participating in these girl sports.
Lower courts blocked Idaho's Fairness in Women's Sports Act.
It would be her first opportunity to compete on the women's team since she started transitioning,
allowing Hecox to compete for several seasons.
A transgender woman in Idaho dropped her legal challenge.
Then in September, Hecox requested a dismissal. After the Supreme Court agreed to hear the case, she cited that personal challenges led to her exit from women's collegiate sports. A federal judge, however, denied her motion. State officials, joined by two former Idaho State University runners, are asking the court to decide whether states can enforce laws like Idaho's nationwide.
The fact that biological males are still beating females in their own sport is insane, and the only way it's going to stop is if we speak up.
The student, Becky Pepper Jackson, has been the center of various legal battles throughout the last 4 years.
West Virginia cannot stop a trans girl from playing on the girls' sports team.
The West Virginia case centers on Becky Pepper Jackson, a middle schooler barred from girls cross country.
In 2023, our state passed a law called the Save Women's Sports Act, which essentially says that if you're going to play sports in West Virginia, you have to play against people that share your biological characteristics.
Like Idaho, lower courts blocked the ban, allowing Jackson to compete. Both states argue they, not federal courts, should set sports rules, citing long-accepted separate teams.
Men are coming into women's sports and taking away podium slots, scholarships. Just in the West Virginia case alone, since the male athlete there started participating, he's taken away over 400 slots of women and displaced girls 1,100 times. So just think about that.
Athletes nationwide are speaking out, including former NCAA volleyball player Macy Petty, who faced a transgender opponent spiking 80-mile-per-hour balls.
This male athlete used his biological advantage and hit the ball into our faces over and over again, completely humiliating us in front of these college scouts.
In Maine, Cassidy Carlisle lost high school skiing championships to a biological male.
We're not telling someone they can't compete in their sport. We're telling them that there is a fair and equal category for them to compete in.
And at least 27 states now restrict transgender students from girls' sports.
We do need some sort of rules here. It can't be just a free-for-all that anyone gets to participate in whatever sport they like. But I do think that rules can be different based on what is the sport and what is the age and what is the level of competition.
The ACLU, representing both plaintiffs, insists the bans are discriminatory and harmful.
When it comes to sports, obviously that's a context in which we allow sex-separated teams, but we can't do that in a way that takes a vulnerable minority and it just excludes them from it entirely.
Meanwhile, major sports organizations, including the NCAA, are also tightening eligibility rules.
We've seen even the International Olympic Committee and the NCAA start to rethink some of their policies. That's a good indicator that there are only so many lies that you can ask the public to believe before they finally take a step back and say, we really think you ought to reconsider this.
What the court decides this term could clarify how civil rights protections apply to transgender students, a question it hasn't yet fully answered. The Trump administration is siding with Idaho and West Virginia. A Supreme Court decision is expected by June. Tara Mergener, CBN News.
Well, the Supreme Court may not rule the way we think it ought to rule, the sort of common sense. If you allow men to compete in women's sports, they have a biological advantage. In a similar case, and it comes from employment law, so it was Title VII, not Title IX, but Title VII of the 1964 Civil Rights Act. And it prohibited discrimination on the basis of sex. In the case that was decided by the Supreme Court, there was a funeral home worker who was transitioning, and he would show up to work. He had a full beard, and he would show up to work wearing a dress, which disturbed the families who were trying to bury their loved ones. And so the funeral home fired him. The Supreme Court ruled that that was discrimination, and the word sex, and back in that act in 1964, meant gender transition as well. So in Title IX from the 1972 Act, which was designed to bring equality in funding in education and specifically funding for women's sports in education, there's no discrimination based on that same word, sex. So is the Supreme Court going to be consistent in the rulings? Are they going to overrule what they did, or are they going to find some kind of different analysis when it comes to women's sports? We'll see, but you know, you get into parsing these kinds of words at the Supreme Court, and it does beg the question, who's really in charge here? Is the legislature in charge? Is the Supreme Court's current interpretation of the law in charge? I don't think anyone who passed the law in 1964 thought how it would be used. And certainly everyone behind the 1972 law was just trying to make it an equal playing field that women's sports would actually be funded. And we're into this sort of strange woke universe in the United States, and it just is against common sense. Men have a biological advantage. Let's recognize that. If you're going to have equality in funding and participation, then women's sports need to be for women.